All right, so we can now start with our discussion for today. Today we are going to learn punishment under criminal law, punishment. It is very important to know punishment is also another aspect of criminal law of which you should not play with it, because based on the 1992 Constitution, Article 19, from the introduction that we have had so far, we have seen that, to be precise, Article 19, Clause 11, we have seen that no person shall be convicted of criminal offenses unless the offense is defined and the penalty for it is prescribed in a written law. So the penalty for it, we are coming to look at the punishment, some of the theories that underpins or that supports the principle of punishment. If you're able to understand it this way, it will make you appreciate our subsequent lessons when we mention punishment. The reason being that you have understood why we are meting or we are issuing punishment. So it is very important for us to get to know much about punishment so far as criminal law is concerned. So quickly we are moving forward under criminal law. When we are done with this, it will be left with three important topics. Which is highly examinable, to be precise, in first semester under criminal law. They are highly examinable, specifically first semester under criminal law. So it is very, very important for us to be abreast with them. Three important topics, highly examinable. And then we say bye-bye to criminal law for first semester purpose. Now, today we are learning punishment. When we talk about punishment, if you look at it carefully, you could see that from our discussions that we have had so far, it is one of the essential elements of the criminal law. Because Article 19, Clause 11 says that nothing qualifies to be a crime until it is being defined with penal consequences. So, if we cannot allocate and associate it with penal consequences, if we cannot allocate penal consequences to it, then it is not a criminal law, or it is not a crime. So we are saying that any statute that tries to issue offenses, in quote, so-called, without any punishment being attached to it, would definitely breach the 1992 Constitution, and thereby shall never be considered to be a criminal statute. So any statute that is in force should have its penal consequences. When you do this, we will do this. When you do that, we will do that. And the moment it is able to do that, then we'll be good to go. So it is very, very, very important. Punishment is very important. There can't be any offense, so-called, without a punishment. So it means that punishment is the backbone so far as criminal law is concerned. However, the definition of punishments has gone through a lot. It has gone through a lot. Lots of people have decided to write on that. Yet they have not been able to come out with exact definitions. So we look at the definition, look at purpose or aims of punishment, and then we end with the theories of punishment. So we are hoping that today will be one of the shortest lectures or classes that we have, trying to see whether I can work within 1 hour and then we are good to go. As I told you earlier, punishment is an integral part of criminal law. And it also gives criminal law its force. So criminal law wouldn't have gotten any authority or power or a force if there is nothing called punishment. So some of us who are parents or some of us who are married, if your children commit something that you don't like it, or your partner, being your husband or your wife, commit something of which you don't like it, and then you refuse to punish the person will definitely repeat it. So what we are trying to say is that punishment is very important because it actually gives criminal law its force. All of us would have been killing if the law is not prohibiting it. But because the law is prohibiting it, it is making it very hard to commit. So that is how it is. So far as criminal law is concerned, we have to look at first-degree felony, second-degree felony. Don't say third-degree felony. We don't have third-degree. First-degree felony, second-degree felony. Then we have misdemeanor, we have fines. So be abreast of all this. All right, so here we go. So here we go. Mensa Bonsu has come here again, trying to give us an extensive definition about a punishment. So Mensa Bonsu says that he sees punishment to be a phenomenon that entails the infliction of suffering or some other unpleasant consequence by an agency in a position of authority on an offender for an offense. Manasseh, can you repeat it for us?
Mensa Bonsu defines punishment as a phenomenon that entails the infliction of suffering or some other unpleasant consequences by an agency in the position of authority on an offender for an offense.
Very good. So today, some of you will be assisting me with the reading because of the voice. All right, so according to Mensa Bonsu, very, 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 very important definition. I don't know how some people might take it to be, but I consider it to be a functional definition. You see, sometimes something qualifies to be called functional definition because the definition tries to cover the function of the thing. If you say, who is a human being? And they say, oh, human being is someone who has been created in the image of God and is able to eat, walk, talk, think wisely, be able to make decisions. Then you say that you're talking about functions of human being. You are defining human being based on functions. So when you look at this one, you could see that it's a functional definition. This functional definition brings out 6 elements of punishment. It brings out 6 elements of punishment. Mrs. Esther is going to read them for us, these 2. So they bring out 6 elements of punishment, of which you must get it in your pocket. You'll be using them. Why must we punish someone? You will need them. So far as criminal law is concerned, every aspect, you will meet punishment. Being life imprisonment, being by death, and what of you? You can talk about them. The punishment are plenty. The punishment are plenty. So that is how it is. 6 elements of punishment from the definition of Mensa Bunsu. The punishment is a phenomenon, number 1, that entails the infliction of suffering or some other unpleasant consequence. Having watched the definition enough, let us look at one of the elements. Message. Message, kindly unmute yourself and read for us. Message, please kindly unmute yourself and read it for us. Oh, all right. Manas, you take it again for us.
Punishment is inflicted on a person found guilty of an offense. This suggests the possibility that it may be inflicted on a person who may not be fully culpable. Should I continue?
Sure. So the first element is that when you talk about punishment, it should be something that you are not inflicting on an innocent person. I think it's laudable. So we can't inflict punishment on an innocent person. In fact, you will even be the person who has committed a crime. So punishment deserves to be meted on someone who is guilty or who has committed an offense. The next one. The next one.
It involves the infliction of some pain or suffering or deprivation. This may take the form of imprisonment, fine, or the imposition of the performance of some service. Therefore, a pleasant visitation is anything but punishment.
A pleasant visitation is anything but punishment. It means that punishment is unpleasant. If you are talking about pleasant thing, punishment is not part. So you can't just buy food, McCoy, or you buy this food. Oh, this my KFC. You can't buy KFC for someone just because the person has committed an offense. And then you're saying, no, you're buying KFC for the person as a punishment. Punishment should be something which inflict pain on the receiver. So the person who is receiving it must feel it. That yes, something is entering my body. That is punishment, infliction of pain, or suffering, or deprivation. Very important. Whether we are isolating you, imprisoning you, we are fining you. From the definition, punishment is a phenomenon that entails the infliction of suffering. Infliction of suffering. From the definition, you could see infliction of suffering, or some other unpleasant consequence by an agency in a position of authority on an offender for an offense. So, Manasseh, you read the next point.
It must be inflicted deliberately or intentionally by the authority of the state. So if the pain, suffering, or deprivation is the unintended consequences of the action of the authority of the state, it is no punishment.
Hey, it shouldn't be consequential. Or how should I put it? What I'm trying to say is that it should be intentional. We have to design the punishment and give it to you for you to know that what you did was offensive. So punishment must be deliberate. The parents here, when you are punishing your children, it must be deliberate, intentional. You take your time, you say, stretch forth your hand, and you hit strategic points that he or she will feel it. When I was a teacher, oh, I used to like the buttocks very much. Some students will prefer their palm to their buttocks. But whether you like it or yes, I will give it to you at your buttocks. Because that is the place that will enter you. If I inflict it on your hand, you might not be able to write. So I have to intentionally, deliberately inflict your buttocks. So punishment must be deliberate. It must be intentional. By the authority of the state. So by the authority of the state is another point. That is what I've captured at the down there. The person or agency imposing the punishment must be in a position of authority over the person punished. Your son cannot punish you. Your daughter cannot punish you. So the person who is inflicting the punishment must have authority over the person receiving. If not, it is not a punishment. So punishment must be received from the state or agency or anyone who has authority over us. These are the elements of a punishment. When you are explaining punishment that should be given to someone who has committed a crime, then you should be able to emphasize these elements. Very important. Wemega, you read the next slides for us. Wemega. From here going.
Punishment must be meted to a person by another. So if a person inflicts pain or suffering or some deprivation on himself, it does not qualify as punishment.
How do you understand this?
Is it to me?
Sure, Honorable.
So, to my understanding, in case I offend or I go against the laws and I intend, I don't punish myself and then it is seen as punishment.
Come clearer.
So, per my understanding to this, punishment is supposed to be punished by a senior authority or somebody who's above me. So, if I intend punishing myself or causing any, like just trying to cause, like to deprive myself or to do something against myself and terms as punishment, it's not qualified or it's not considered as punishment unless it is done by another party.
Excellent. So you can't just try to say that, oh, I have committed a crime, so I'm going to beat myself, I'm going to slap myself, or I'm going to lock up myself in a room. That is not a punishment. A punishment must be inflicted. It must be meted to a person by another. In fact, if you are even inflicting the punishment on yourself, in the old law of Ghana, that might have constituted a suicide. So you can't punish yourself. Bring yourself and let us punish yourself for you. So that is the law. Wemega, let's go.
Punishment is related to the commission of a crime. It cannot be imposed in a vacuum. It must be the consequence of the commission of a crime. Therefore, punishment cannot be imposed before the commission of a crime. Minority Report. Some writers suggest that a feature of punishment is that it symbolizes an expression of disapproval for the violation of a rule.
Manasseh, how do you understand this? Mrs. Is Mrs. on the line? Mrs.
Yes, she's on the line.
Okay, I think she might be away from the phone. Yes, Manasseh, how do you understand this? Punishment is related to a commission of a crime. Punishment related to a commission of a crime. Related to a commission of a crime. You don't just give someone punishment. While
So,
someone is working. Manasseh, let's go.
as we've previously discussed about crime and its punishment, once a crime or an offense is being committed, there is a penal consequences towards that particular crime or offense. So if punishment must be the consequences of a commission of a crime, it shouldn't go beyond or below or above or beneath or deviate from the particular crime or punishment that should be given to the person. That is my idea. I don't know if I'm wrong or right.
It is absolutely correct. But unknowingly, you have even introduced something very important. Unknowingly, what you have said, you have introduced a very important concept in criminal law, the concept of proportionality. You said that it shouldn't be below, too above. The punishment shouldn't be below the crime that has been committed. Someone has committed murder, and you are fining the person. If that be the case, then we can all do it. That is why the Criminal Offences Act prohibits families to sit on rape matters. If you're a family abusuapani or family head, if you're a mother or a father, if you are a chief or a king, if you are MP or a minister, if you're a pastor or a sorrypenny or a church head, and you will sit on rape matters in the house without making reference to court, you'll be in trouble. So the reason being that the quantum, specifically the first degree felony cases, the quantum of the case is in such a way that it is not redressable by just having mediation, negotiation, or even a mere arbitration. It must go to court. Sometimes it's not because the person is becoming too straight. No. But because if the person doesn't take that step, and then someone even go and give the court a hint, or the police people a hint, all those who sat on the issue will be in trouble. So it is very, very important. Punishment must be proportionate or proportional to the offense that has been committed. So punishment shouldn't be too high. The person broke traffic light rules. You want to sentence the person 70 years. It is irrational. Someone committed murder. You want to give the person 2 years. It is too low. Someone committed manslaughter. Manslaughter, I think, is second degree felony. Second degree felony is a day or a term of imprisonment from, I think, a day up to 25 years, though the statute does not mention it, but that is the norm. So punishment should be proportional, should be proportionate, highly proportional to what has been committed, the offense that has been committed. So we look at the offense that has been committed, and rationally, we met or we allocate the appropriate punishment thereof or the appropriate sanction. So punishment is related to the commission of a crime. If you haven't committed a crime, why should we punish you? So there must be a commission of a crime before we punish you. So all crimes must be punished. Whether you like it or yes, all crimes must be punished. That is how it is. So if you look at it carefully, we have discussed 6 elements. One is punishment is inflicted on a person found guilty, not innocent person. Someone who has committed an offense. Someone who is proven guilty, who is convicted, is the one we punish. Number 2, it involves the infliction of some pain. Yes, and punishment is inflicted on a person found guilty. The person who is found guilty, we inflict pain on the person. Let the person feel it. Let the person feel that there's fire somewhere. So there should be an infliction of pain or suffering or deprivation. So if you have committed an offense and then we have put you into prison or somewhere of which you are now even benefiting, you are now enjoying like when you were outside, more than when you were outside, then it is not a punishment. There must be an infliction of pain or self-deprivation. It must be inflicted deliberately or intentionally. That is where the point ends. By the authority is the next one. So it must be inflicted deliberately or intentionally. It shouldn't be like when you are sleeping and then we come and slap you and you don't hear it or you don't feel it. No, we are not doing like that. We will let you see it and then we punish you deliberately or intentionally. So when you are punishing your child for committing a wrong, do it deliberately. You can decide to punish him or her when he or she has finished bathing. Deliberately, you want to inflict some pain so that the person will not do it again. Deliberately. It does not necessarily mean that you should kill the person. Criminal law does not persecute, it rather prosecute. So you don't do it like killing the person, like hurting or harming the person. However, you want the person to feel it, that what he or she did, it is because of that you are inflicting this pain. Then the next is that the person or agency imposing the punishment must be in a position or authority over the person that he or she is punishing. So the one who is meting the punishment, who is allocating the punishment, must be in authority. So if we are all citizens, we are all just mere civilians, you can't punish me. You can't punish me because you are like me. So you can't punish me. However, the situation whereby the person is in authority to do so, the person can punish you. Your own child cannot punish you. But you can punish your child. You must be in authority before you can met punishment. Punishment must be meted to a person by another. If you slap yourself for committing something, for committing a wrong or a crime, it is not punishment. You have broken the rules of traffic and you want to go and give money to children's house or children's home and say that I committed an offense, so I'm giving money here. That means I've paid my fines. You lie bad. That punishment must be inflicted by another. it must be inflicted by another. That punishment must be related to the commission of a crime. No punishment should be given in a vacuum or in a vacuum. The person hasn't done anything. You want to give the person punishment. For what? Do you just hate the person? That is why you are doing that. So that is how it is. Punishment is related to commission of a crime. Let us look at some of the purposes of punishment. Purposes of punishment. Manasi. Manasi.
Deterrence. Deter people from committing crime in the first place by using the threat of punishment. Specific deterrence, deterring a certain individual from offending, into bracket again, deter A from offending again. Yeah.
So we have deterrent. Why do we punish? What is the aim for punishing? What are some of the purposes of punishment? Why do we punish? Number one is to deter. We want to deter people from committing crime in the first place by using the threat of punishment. So if we want a particular group of people to stop committing a particular wrong or crime or an offense, you have to allocate a punishment to it. You should be able to allocate punishment to it. So a punishment that does not deter is not punishment. It must deter people. It must let people get to know that no, if I do this, I will be punished. So I won't do it too. I won't do it. I won't do it. So when you look at the case of Stewart, S-T-E-W-A-R-T, S-T-E-W-A-R-L, S-T-E-W-A-R-T, S-T-E-W-A-R-T, Stewart. The court upheld a sentence of 3 years imprisonment passed upon a boy of 16 years for robbing and beating up 2 elderly women in a sub-post office. In fact, this young boy beat this elderly woman with a hammer. A hammer. So Lord Parker, I told you about Lord Parker, one of the famous judges in UK. So Lord Parker, Chief Justice Lord Parker said, their lordships were quite prepared to accept the view that the appellant was unlikely to commit a similar offense again, so that the best course from the appellant's point of view would be for him to continue his education and to receive some disciplinary training. However, a substantial period of imprisonment was the only appropriate penalty in order to show young men that they could not commit this kind of offense with impunity. You see old women, let it be men in prayer, old women, and you are beating them with hammer. Hammer, not a cane, hammer. He's a 16 years guy. He's supposed to be in school. But Lord Parker said, so that the appellant will not commit such offense again. And to also prove to every young man that they can't just do this. Anytime they do it, serious punishment shall be meted on them. So that was a deterrence. The purpose of the punishment, the Chief Justice Parker, or let me say Lord Parker, was to deter the young boy from committing such offense again, or to speak to the entire society that you can't just rise up and be beating elderly people. You can't just rise up and be beating elderly people. Whether you profess them to be witches or witchcraft or whatsoever, or wizards. You can't just rise up and be doing that. So we have to increase the quantum of the punishment in order to deter others from doing it. That was the case of Stewart, Stewart, Stewart. So far as deterrence is concerned, we have two types of deterrence. We have what is called specific deterrence, and we have what is called general deterrence. Specific deterrence, and then we have what is called general deterrence. When we talk about a specific deterrence, we are talking about discouraging the individual offender from repeating the commission of a crime that it seeks to prevent. So the specific deterrence seeks to prevent new offenses to happen after a crime has been committed in the past. So we don't want similar offenses to be committed again. By the virtue of that, a specific deterrence is given, specific punishment is given, so that no one can commit similar act aftermath or afterwards. We also have general deterrence. General deterrence. It is very, very, very important. So sometimes too, the reason why the court issues serious punishment is to prevent the general public. So they do that to deter many people from offending. So if they want to prevent the general public from offending, that one becomes general deter. If specific person or the person who committed offense is the one that the judges are trying to prevent from fighting, then that one becomes specific deterrence. That one becomes specific deterrence. But if it is supposed to be issued against the general public, then it will become general deterrence. We have what is called restraint or incapacitation. Incapacitation. Wemega, you can read it and explain it to us.
Incapacitation or restraint. Incarcerating offenders to render them incapable of offending again for the duration of the incarceration. Put them on ice.
How do you understand?
So, my little understanding on this, in a layman's idea, restraining the person. Okay, so restraining the same word, like preventing the person to have certain access to certain things, or to restraining preventing the person from having access to maybe the opportunities the person had to commit certain crime for a period of time, to prevent the person from maybe enabling him to do so the next time.
That is absolutely correct. You incapacitate the person. You incapacitate. Probably the person was in a particular position that gave him the chance to do it. You take the position out and you punish the person. Restrain the person. That one also is there. You can restrain the person. That one will prevent the person from committing further crimes. So that one also is a punishment. So punishment is not only beating a person or putting a person into prison. It is like this: as a father, you trying to prevent your children from watching television because they fail to go on errand that their mother sent them to go. Hey, you, Alex, today when your mother sent you, you didn't go. Fine, I hear. The laptop I bought for you today, you will not use it. Then you take the laptop out. Hallelujah. Oh, one can amen. We make a amen.
Amen.
So what you are trying to say is that it is only sometimes in the African nations that we see punishment to be beaten. It is always not the case. Sometimes you reduce the chop money of your child. That is a punishment. You render the person incapacitated. Probably the person has to pick car before going to school. You reduce the chop money. So he will be confined either to walk to school so that he can use the chop money to buy food, or to pick car and go to school and suffer from hunger. You have reduced the money. So punishment is not always beating, kick out. You're always knocking a person's head. You're always slashing the person. That isn't the punishment. That isn't the only punishment. So we have general deterrence. We have specific deterrence. Specific deterrence. I have a case here in front of me. It is Kwashi. I don't know. I think I put it down so that we can read it together. Good. I think it's here. We can read it together. So, Wimega, can you read it for us?
Kwashi versus the Republic. An appeal case. So in Kwashi,
Mr. Manasi,
where
respectfully, could you call Mrs. for me? Probably, yeah, probably, yes. Okay, so
should I wait? Should I they come?
Okay, let's wait for them.
Okay.
So, Wimega, you can start the reading afresh for us.
Kwashi versus the Republic. So in Kwashi, where police officers seize contraband goods and use them for their own selfish design, it was held on appeal that since the offense was of a very grave nature, the sentence must not only have been punitive, but it must also have been deterrent or exemplary in order to mark the disapproval of society of such conduct by police officers. And that when a court decides to impose a deterrent sentence, the value of the subject matter of the charge and the good record of the accused become irrelevant. In determining a sentence, it is proper for a court to consider, on the other hand, the social or official position of the offender, and on the other, that the offense may be aggravated by reason of such position.
I hope you understand it. I've also given a space for you to think through about it. So, in determining a sentence, it is proper for a court to consider, on the one hand, the social or official position of the offender. So, before we issue deterrence, we will consider your position. You are a lawyer and you have broken traffic offense, traffic rules. You are doomed. So one of the disadvantages of being a lawyer is that when you get a case at court, you are doomed. You are doomed. You are doomed. It is one disadvantage of a lawyer. Make sure that you don't get a case at court. If not, you will see pepper in your eyes. So we look at the official position of the person. You are a police constable or a police officer. And then someone has stolen something and the car is coming. Quickly, you just seize the car and then you take everything in it and you start apropos using them or appropriating them. That is not good. That is something that we are not supposed to tolerate in the society. If we don't do this to deter the other policemen, they will do some. So let us let the punishment to be too much so that it will serve as an evidence or example for the rest. That's the deterrence. Now let us look at requirements of criminal liability or the groupings of liability. It's the same thing that also applies in the law of tort. The same thing that applies in the law of tort. So groupings. Manasseh, I think you can check from our platform and then you read it for us. The groupings of a liability. So Manasseh, be checking it for us.
Is it the last one?
You see straight, absolute, vicarious, based on fault.
So, in the context of criminal law, the concept of liability can be classified into 4 categories: strict liability, absolute liability, vicarious liability, and liability based on fault.
So liability, how could we know? And then met punishment, you have to get to know the liability. Yes.
Strict liability. Strict liability.
Very important.
Strict liability is a legal doctrine that holds a party responsible for its actions without the plaintiff having to prove the negligence or fault on the part of the defendant. This type of liability is imposed on a party that engages in ultra-hazardous activity, such as keeping wild animals, using explosive, or making defective products. The defendant may be held liable if any other person is injured because of this activity, even if the defendant took necessary precautions and followed safety requirements. The rules was established in the case of Rowlands versus Fletcher. Should I continue?
Okay, so far, which one have you read?
Strict liability.
Strict liability, right?
Yeah.
Okay, so to better understand law, it must be read twice. So respectfully, let us read it again.
Strict liability is a legal doctrine that holds a party responsible for its actions, without the plaintiff having to prove the negligence or fault on the party of the defendant. This type of liability is imposed on a party that engages in ultra-hazardous activities such as keeping wild animals, using explosive, or making defective products. The defendant may be held liable if any other person is injured because of that activity, even if the defendant took necessary precaution that follow safety requirements. The rules was established in the case of Rowlands versus Fletcher.
So that is strict liability. Over there, we don't grant you the opportunity So let's read it here. Liability is said to be straight as long as it can be shown that a person's act or omission has resulted in a particular undesired result. In this case, it is immaterial whether he was at fault or whether he is morally blameworthy. However, he is afforded defenses, if any defense is available to him. So straight liability, the thing you are doing, probably you might have not brought it on anyone, but actually the thing, we can't tolerate it. Why should you be keeping lion in your house? There are some particular guns that a civilian is not supposed to handle. If you handle it, even if you're using to protect the community, you'll be in trouble. It is straight liability. Be careful. Absolute. Yes, Manasi. Manasi. Okay. Oh, Manasi. Manasi, you can read that one for us.
Hello?
Yeah, can you
Hello?
hear me? Hello?
Yeah, my network was breaking. Yeah, I can hear
Sorry.
you now.
So we read straight. Could you respectfully read absolute for us?
Absolute liability is a legal doctrine that says a defendant's intent doesn't matter in determining if they should be held accountable for a crime they committed, or if they should be made to compensate injured victims in the personal injury claim. It is more stringent from the stringent form of strict liability. Should I take it again?
Yes.
Absolute liability is a legal doctrine that says a defendant's intent doesn't matter in determining if they should be held accountable for a crime they committed, or if they should be made to compensate injured victims in a personal injury claim. It is a more stringent form. It is a more stringent form of strict liability.
All right. So absolute liability is where the defendant's moral blameworthiness is immaterial and he is afforded no defense. So straight liability of defense is available, but absolute, there will be no defense for anyone who is subjected to absolute liability. No defense. We don't take your intent into consideration. You have done it. You have done it. So kindly, please, I beg you for the last time for me.
Absolute liability is a legal doctrine that says a defendant's intent doesn't matter in determining if they should be held accountable for a crime they committed, or if they should be made to compensate injured victims in a personal injury claim. It is more stringent form of strict liability.
Is it clear now?
Yeah.
How do you understand it? Wemega will read the remaining two. Honorable, how do you understand it? Oh, Manasi.
I'm here.
Yeah, share your mind on it. Absolute.
So with the absolute, as I read, it doesn't matter. It doesn't matter the intention of the defendant. Once the crime is committed, it is like it is just there, as in either, let's say if it's you hit someone or something, then there's an injury. If there is a claim, it's there. Like you need to do that. Let me put it as let's say it wasn't your intention to hurt someone, but the person is hurt. So the person goes to hospital, and then the bills and all that, like it is absolute for you to pay. That is how I understand it. Hello?
Yes, you are. When you finish reading, you have to let me know.
Okay.
Uh-huh. So that it won't be like I'll cut your mouth.
Okay, so I'm done.
Very good. So when the act is committed, we don't give the person opportunity to come and say that I'm come to defend myself. But it is some kind of authoritative. Is that not the case?
Yes.
It is too authoritative. Absolute. So it doesn't normally happen in Ghana. Democracy. Say some, let me say some. All right.
But I have is it a question or something? Like I once witnessed a court case, like personally in the court, and the case, it was a civil case, but it was filed by the legal counsel under undefended list. That was the term used. In that case, the defendant doesn't have any defense based on the documents provided. In that case, could we say it's an absolute liability?
I still don't get you.
Okay, so there is a case in court as it stands now. Okay, it's a civil case. It's between let's say between Manasseh and then Emmanuel. Okay, and the whole case is Emmanuel is owing me some money that he needs to pay me, and there is a contract that shows, or a letter to prove that, yes, or an undertaking that states that Emmanuel is owing me, and he will pay within this period of time, and Emmanuel hasn't fulfilled that part. So in filing the case to court, the legal counsel filed the case under undefended list, as in the defendant doesn't have any defense to come and batter the whole case. I hope you are getting me. Oh, it's my network.
Okay. And then read what you read again, and then we just oppose the two for you to see it.
That is the absolute, right?
Absolute.
I'm taking it again.
But before you even read it, let me let you know that the absolute could be either applicable in civil matters or criminal matters.
Okay.
In civil matters such as tort, law of tort, it is applicable there.
Okay. So absolute liability is a legal doctrine that says a defendant's intent doesn't matter in determining if they should be held accountable for a crime they committed, or if they should be made to compensate injured victims in a personal injury claim. It is more strengthful form of its liability. So my question is, with
So
the
at the
case,
moment you are not going to grant the person a defense,
yes,
then it becomes absolute.
okay, but then
Wait,
the
wait. It is like, I don't know whether it is a real Kuto case.
no, it's not Riakoto case. It
No,
is
no,
not.
no. Like, I'm talking about something.
Okay.
There is a case in constitutional law.
Okay.
I don't know whether it was Ria Kutusu, who was being detained by the then president, because the constitution gave the president authority to detain someone. They didn't give the person defense also. It just detained the person. So that's his authoritative style. It is authoritative style. So whether it is a civil case or a criminal case, it does not nullify the fact that it is absolute. Because absolute liability could be in civil matters, law of tort, or what you are discussing here under the requirements of liability. Their classification of liabilities. It could also be applicable in tort. Okay, yes, move on.
So once the case was filed as undefended list, meaning it's an absolute liability, right?
Undefended.
Yes.
Sure, absolute.
Yes. But then the court has the power to also give audience to the defendant, regardless, right?
That is why I'm saying that it is very hard to see some in Ghana.
Okay, because
we have the principle of natural justice. Audi ultram partem. Audi ultram partem. Here the other party. The principle of natural justice. They are built on Audi ultram partem. Here the other party. So there are two principles under the natural justice. When you are doing constitutional law and administrative law, you appreciate it. Audi ultram partem. Here the other party. Or here the other side. That is Audi ultram partem. AUDI. ALTEREM. Ultram. Partem. PARTEM. Audi ultram partem. Here the other side. So you can't make a decision whereby you have not heard the other side. The same thing happened in the case of Accra House of Oak versus Ghana Football Association. The Audi ultra partem rule, here the other side came to play. If you want to hear the brief fact of the case, then I don't know whether you have time for it. So it is against the absolute. It is against. When you check the case of Abuaje versus Ghana Commercial Bank, the rule of Audi ultram partem also came into place. So here the other say, or here the other party. And then you have Nemo Judex in Cosa Sua. Nemo Judex in Cosa Sua. No man should be a judge in his own case. So you are a judge of the Supreme Court, yes. But if you get a case, you shall not sit on your own case. If your mother gets a case, you cannot sit on your mother's case. If your father gets a case, you can never sit on your father's case. If your wife gets a case, you can never sit on your wife's case. Again, you can never sit on a case that you have something to do with the parties. Probably you have contractual agreement with them. Or the two of you have had past encounter. Something like fighting over something. That is Nemo Judex in Cosa Sua. No one is the judge of his own case. That is the rule against bias. We check the case of Akosua Bedabuo versus Yahima. That case is interesting. There was a judge who liked one. And then he sat on the case. It was interesting. Oh, Jesus. Law is interesting. Law is interesting. Law is interesting. Hey, assume I'm a judge and I like your wife. And the two of you have gotten a case and you have brought it to court. What do you expect me to do? Hey, law is interesting. So that's the rule against. Let me give you the fact of the case of Akosua Bedabuo versus Yahima. In this case, there was a land dispute between two women, Akosua and Yah, which was held by a panel of 5 members. A panel of 5 members which gave judgment in favor of Yah. The defendant, Yah. So the case was held in favor of Yah, the defendant. After the judgment was given, the president of the panel married Yah. 5 panels, so 5. The case was given in favor of Yah. After the judgment was given in favor of Yah, the president of the panel married Yah. That was the defendant. So straight away, Akosua appealed the case. He appealed against the judgment. The court which held the appeal ordered that a different panel should hear the matter again, because the court was of the view that there was a rare likelihood of bias based on some form of interest. The rule against bias, 2 rules hold natural justice. Charlie, let me be your mentors. Let him be your mentors. I feel like imparting knowledge. I feel like bringing law from the book to down. Taking law from books and bringing it to the memory of students. Oh, law. It's one of the easiest course or easiest programs because it is lovely. So that is the absolute. The rule of natural justice. Odi or Trumpatem. Odi or Trumpatem. And the Nemo Judas in Cosa Sua. No man should be a judge in his own cause. The rules of natural justice, these two maximum rules, two fundamental rules of natural justice. So it nullifies the absolute. You don't give the person defense. It's unconstitutional. You have to allow the person to defend himself. Hear the other party. Hear the other party. Hear the other party. So that is how it is. That is how it is. Can we move on? Hello, can we move on? Hello?
Yeah, let's move on.
Okay. I wish to end soon. Wherever we will reach, and then we end it, I don't think we'll be able to come back and look at it again. So let's speed up. So we have checked it. And then we have liability based on fault, whereby a person's actions or omissions by themselves will not render him culpable unless he is morally blameworthy for that act or omission. A person is morally blameworthy. Liability based on fault. It is a liability we are bringing upon you. It is a liability you are incurring because you yourself, you committed the thing. You yourself committed it. You are morally blameworthy. So that is it. The next one is vicarious liability. I think I explained this one in the informal session. Holding someone responsible for the act that another person has committed. It normally happens between masters and servants. So vicarious liability, when someone commits something and then you hold the other responsible. Hospital, when a doctor commits a mistake, a nurse commits a mistake, you hold that particular hospital responsible. If it is a private hospital, or you hold Ministry of Health responsible. Police, if a police does something, you can hold the police department. Sometimes I think the Attorney General who normally stands in for them also. A teacher, then you hold Ministry of Education vicariously because they employ the person. If someone is driving your car and the person negligently hits someone, we can hold you vicariously liable. I hope you are getting it. Anasi.
Oh, I'm getting it all.
Very good. Now, Wemega, are you on the line? Is Wemega there? So, I've also taught you vicarious liability. So, look at where we were. Sorry. We're looking at offenses based on fault. We have looked at that one. And then we have looked at straight liability, absolute, and vicarious. Good. Based on fault, straight, and absolute. But before we go, let us quickly read a particular case. Let us read a particular case. Melfa versus the Republic. Manasseh, let's read it together.
The appellant had gone to a pub to have a drink and was sitting at a table quite different from that at which the deceased, an international footballer, was sitting with his friends. The deceased had a quarrel with one of his own friends and had a fight ensued between them. The appellant did what any reasonable man would do by trying to separate the two. The deceased picked upon the appellant and beat him up and threw him onto a fence. Friends who were present advised the appellant to leave. The appellant's version was that he immediately left the bar, but was shortly after followed by the deceased, who had removed his shirt and who attacked him again by beating him up. In the 42 phase of the beatings, he picked up a broken bottle and warned the deceased to stop beating him, but the deceased still advanced and he stabbed him. He was convicted of manslaughter and sentenced to 8 years in prison. The only reason the trial judge gave for the sentence was that this was a crime of violence. On appeal, it was held that each crime of violence should be considered on its own merit when inflicting penalty on the perpetrator, and that if the trial judge had considered all the facts in relation to the crime, he would not have imposed such a long sentence. This was because it appeared quite clearly from the evidence that the deceased was a man of violent temper and he was the aggressor in this unfortunate incident. In the circumstances, the sentence was reduced to 4 years. Thus, even when imposing utilitarian sentences, judges are sometimes at pains to stress that the punishment must be proportional to the offense committed.
So, Manasseh, you see your case, the proportionality.
Yeah.
Very good. This brings in the theory of punishment. The theories of punishment. The theories of punishment. But before then, don't forget that we're talking about the purpose of a punishment, of which we look at deterrence. We said that we have general deterrence. We have specific deterrence. So the general deterrence, the specific deterrence, that led us to read the case of Kwashi, whereby a police constable diverted a stolen goods. He seized them and then he used them for his personal gain. You remember that incident?
Yes.
So that was the purpose of punishment, the aims. That was one of them. So that is what actually led us to go and read the Kwashi case, Kwashi versus the Republic. And then another purpose, we realized that it is about restraint. Another purpose is about rehabilitation, through correction. Sometimes we try to take the person out, we imprison the person so that the person will change from committing such mistakes. So we try to, the person is too aggressive. Okay, let the person go to jail and come. Before the person comes, you see that the person has become calm. So that is how it is. You see that, no, this offense was as a result of the person not taking part in, let me say, it's as a result of the person not being employed, or the offense actually ensued because the person is not working. If that be the case, then they will add labor to the person's sentence. And when you go to prison, you have to work for the government. They want to teach you how to work so that when you come out, you'll be able to work. We have retribution. Retribution, I discussed with you Earlier on, I said that it's a retaliation against wrongdoers for his offense. It is a sort of advenge or vengeance or payback. You are retaliating. You let the person pay for what he or she has done, or you can even declare the person to life imprisonment or death sentence. Retaliation, you are retaliating. So retribution, extreme version of retribution, is eye for eye and then tooth for tooth. Moses' law, eye for eye and tooth for tooth. We have denunciation, education, denunciation, denouncing offenders to show them and others that society abhors the offense. So where the person, the position that the person is, if the person is a student or something like that, you denounce the person. Sometimes you punish someone by taking away the position from the person. You denounce the person, put your position down before you leave. You let you put your position down before you leave. So that is how it is. We have what is called prevention. Prevention, the focus here is removing the individual offender from society to render him physically incapable of committing further crimes. You remove the individual offender from society. Remove the person from society so that you can render the person physically incapable of committing further crimes. So that is how it is. We have what is called atonement and reparation. Atonement and reparation. R-E-P-A-R-A-T-I-O-N. R-E-P-A-R-A-T-I-O-N. Reparation and atonement. Here too, the offender is made to compensate the victim for the damage or injury resulting from his criminal conduct. So that is how it is. And then we have theories of punishment. We have retributive, and then we have utilitarianism. When you get time, then you read around them. Utilitarianism. When you get time, then you read around them. So two themes. We have the classic retributive theory. That one we are talking about, steep in revenge. That one is aggressive one. Eye for eye. The offender is supposed to be punished exactly as what he or she did. And then we have proportionality theory. Punishment must fit the crime. That is the moral culpability of the offender justifies the punishment. You don't go and then issue big punishment. This one could be supported by the case of Melfa versus the Republic. Proportionality theory. Melfa. You were fighting and someone was trying to separate the fight. And then you switch the fight onto the person who was trying to separate you. You started beating a person up. You threw the person into fence. You don't know the person anywhere. You were fighting. The person was trying to cool you down. You threw the person into fence. And then the person says, okay, fine, I won't fight you. I decided to separate you from fighting or to prevent you from fighting so that you don't get a case. But if this is what you're doing, fine, I hear you, I'm going home. And then the person is going home. The appellant is going home. And then the deceased followed the appellant again to go and beat him up. And then he started slapping him up about 40 times in his face. And then extreme provocation, you will do it. It's a defense. Extreme provocation. If you provoke someone extremely, I hope you could hear me.
Yes.
Good. If you extreme provocation, if you provoke someone to a high extreme, the person it kills you, you let the person kill you for free. It is not going to be murder. It's going to be manslaughter. If the person even gets a good lawyer, look at this case. So initially, crowd 8 years, it was too small. Me, I was saying that it was too small. For manslaughter, 8 years is too small. Some get 15 years, 16 years, 20 years. 8 years is too small. And even the 8 years we are saying it is too small. The court was saying that it was too much. So they reduced it to 4 years. So he has killed him for free. So proportionality. Melfa versus the Republic. Melfa's own. The punishment was supposed to be proportional to the case at hand, because he didn't intentionally want to kill the person, but because of person's own violent acts that led to his death. So therefore, those who are for retributive theory, that's what they are saying. So this is what they are saying. So you can look at it and read it. Here are theories. Those who are against the retributive theory, this is what they are saying. You can read through for yourself, then we are good to go. It is law, but it is not law. Then the deterrent theories, those who are for the deterrent, you do it to deter people. This is what they are saying. It discourages the general public from undertaking criminal acts. Sorry. Then rehabilitation theory, those who are for, is what they are saying. Those who are against, all of them have their advantages and their disadvantages. So no one will ask you in law to list the advantages and disadvantages. So it is law, but it is not law. Now the concept of utilitarianism says that the law must ensure the greatest good for the greatest number of people. So this concept, utility, they look at the outcome. It is a concept in a lot of issues. Someone has broken out of chain, and then he is killing a lot of people in the community. If that person is being killed by someone, everyone will praise the person, though the person has committed murder. But everyone will praise him. But everyone will praise him. The reason being that the end is what we look at. We don't look at the thing itself. So according to utilitarianism, you can do a lot of things. Oh, you can even do wrong. But so far as the end results in giving the greatest good for the greatest number of people, then it is considered to be good. It is considered to be good. So someone can go and steal money, come and distribute it for the poor. According to utilitarianism, they are saying that the beginning is not important, but the end, when the person stole the money, what did he use it for? The end. So they are interested in the end justifies the means. So it could be seen in the case of Kwaku Frimpong versus Iboman. Kwaku Frimpong at Iboman versus the Republic. I think I've put it on the platform so you can read it for us and then we close. You can read it for us and then we close. Now, when you check the case of, when you check the classification of liabilities, you can call them VABS, V-A-B-S, VABS. V stands for vicarious liability, VABS. A stands for absolute liability, VABS, V-A-B-S. B stands for based on fault. And then S stands for straight liability, VABS, V-A-B-S, VABS. So that is how it is. You can read the case of Kwaku Frimpong at Iboman versus the Republic, and then we close.
I don't know if Emmanuel can. If Emmanuel is online, I've started driving, so
it is on the
be
platform.
difficult for me to read.
Mrs.
Mrs. is not here.
Okay. I heard a woman talking from behind. Probably it might be your wife.
Yeah.
Okay. Could you read that case, or it is not close to you?
No, I'm driving, so it will be difficult.
Okay, no problem. Then I think we will go and search it ourselves. Okay. So that is how it is. So we will bring our class to a close. So in our next lesson, that is the ones that are highly examinable. So far as first semester criminal law are concerned. We are going to look at actus reus, mens rea, causation, extreme provocation. So make it a point to be available. Once again, my name is Possible. And until we meet again another time, I'll say bye-bye for now. If there's any question, you are welcome.
No question.
Take care.